Welcome to another edition of Question and Answer with a Criminal Defense Attorney. My name is Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about restitution. But don't forget to click like if you're enjoying this video and subscribe with a little bell next to it to be notified of future videos. Clicking subscribe and like really do help, so please do that. So let's get to the question. Restitution. Let's start with what restitution is. Before I get to the statute, I'm gonna tell you everything you're gonna need to know about restitution in a nutshell, and then we'll look a little bit at the statute, but I'm not gonna get too deep into it because, truthfully, restitution can be complicated. Restitution is basically to put the people back into the position they were before the alleged criminal conduct. Could be a traffic case, could be a criminal case. It's if your actions have caused some sort of financial loss to somebody else, that's the restitution. It's putting them back where they were. So in other words, if a car crash caused somebody's car to be damaged and you're being charged with careless driving, reckless driving, DUI, whatever, and the other person has to fix their car, the damages to their car are what we'd have to look at. If the person had insurance, or if you had insurance, and the insurance is covering their loss, then that's not restitution. That would be lumped into what's called civil damages. So restitution is not civil damages. Civil damages are a lot more broad. When we look at a case where insurance is involved, if you hit somebody with your car and they had to pay a deductible because you had no insurance, their deductible would generally be, anywhere from $0, $250, $500, $1,000, that sort of thing. However, if you hurt somebody and they have medical expenses, their restitution will include the medical expenses or the deductible there. In today's world, though, you have to be careful because restitution on or the deductible on a hospital bill can be really high. Some people have deductibles of $6,000 to $12,000, and if that's what they had to pay to get their medical treatment, then the restitution would be whatever their out-of-pocket costs were. So in today's world of the Affordable Care Act being expensive, if their deductible is high, that's going to get lumped into restitution. Let's go ahead and look at the statute now. So first off, we look at the definitions of what is restitution. And so we scroll down here to any pecuniary loss suffered by a victim. It includes all out-of-pocket expenses, interest, loss of money, and so forth. It also includes medical tests and so forth if they had to get tested. It can also talk about the cost to government, which is important because government can get restitution. And in fact, in a lot of DUI cases, they call that the cost of prosecution. And interestingly enough, is in DUIs involving breath tests, that often includes, I think it's about $10, $15 for the little plastic tip, the disposable plastic tip they put on the DUI machine. So all those things are technically considered what is restitution. And then we look at the, there we go. Then we look at the actual restitution statute, which essentially talks about what I've already said. In other words, restitution, it's due to the person who was out of pocket because of the criminal behavior that somebody's pleading guilty to or was found guilty of. And then it does not include the actual insurance amount. There's some other things like lost wages and so forth. But when we look at restitution in cases, importantly, it could be anywhere from, a minor or inconsequential part of the case all the way up through the most important part. Now, I know I've been hired in more than one cases because we're contesting the restitution, and that's why we're going to trial. That's why we're doing all the things we are. I remember I did a case where they wanted restitution of several $1,000s for damage to a parking lot. And so we literally went out, took pictures of the parking lot, interviewed one of the witnesses, and, none of the damage to the parking lot was actually caused by my client's behavior. So we were able to save him a bunch of money there. So another interesting thing about restitution, I think everybody should be aware of, is that they can reserve restitution for up to 91 days, meaning that at sentencing, the judge has to enter an order about restitution unless the district attorney or the prosecutor asks for restitution to be kept open. And the most they can do that for, in general, with a couple limited exceptions, is 91 days. So often in some sort of a sentencing hearing, the district attorney will say restitution reserved for 91 days, and the judge will do that, which means that we're going to have to deal with restitution later. Often it either means they don't know what restitution is, they don't know the amount, or they haven't been able to get in touch with the victims to be able to find out if there is any restitution. And the defendant always has a right to a restitution hearing where we can contest whether it was related to the criminal conduct or what the amounts are, and that's one of the things that we can often contest. So that is the question and answer for today. If you would like your own question answered in a future video, don't forget you can email it to me, put it in the comments, or tag me on Twitter. And if you have ever run across a police officer, you should know you have a right to remain silent. If they ask you what you have, where you've been, or what you know, or anything, you have a right to say, I don't want to talk to you, and if they persist, that you want an attorney.